Well, you would file a petition in Orphans Court challenging the will, saying that it was a product of undue influence. There was fraud involved in the writing of it. The person, when they wrote it, was drunk, on drugs, and the person who got them drunk or got them high was a bad person, the evildoer, and we sort that out. But that's where the mediation comes in. Litigation can be a very expensive process. Mediation is a much less expensive process. Hopefully, most of the time, it's a one-shot deal. You resolve the case the same day you start it. So when they come in, my job is to facilitate a resolution, to make sure that both sides understand what their strengths and their weaknesses are. I've been in trial so many times that the lawyers who bring their clients to me know that I've been there and I know what's going on in their cases because they also write like a real short synopsis of their cases so that I can review it and say, okay, so this is the so-called undue influencer. This is the person who was the child and thought that he or she was getting everything under mom or dad's will.
Now, that's the benefit of mediation or arbitration in any practice group, really, whether it's civil or orphans or family court, because as John alluded to, there's a lot of uncertainty, a lot of cost, a lot of time that has to go into waiting for those cases to go to trial. I've won cases I probably should have lost, and I've lost cases that I was confident I was going to win. And those are things that you need to have conversations with your clients before proceeding, or whether you want to explore the option of doing some sort of alternative dispute resolution. And that's where we come in, because we're not just trying to pitch a product, so to speak. We're talking from a position of having been there and done that ourselves, having to deal with clients, any client, whether it's an orphans court matter, civil court, family court, whatever it happens to be. There's an amount of emotion that takes part. They're aggrieved in some way, or they feel an emotional attachment to certain facts or certain aspects of the case. As the advocate, as the attorney, we have to be the dispassionate advocate for them and try to explore all options. That's what we try to explain to attorneys on both sides of the courtroom, that we're an option for them to try to get this to resolution a lot sooner with a little bit more control, and empowers in the mediation aspect. The parties are the ones who are empowered to come up with that resolution.